It's going to be a bit of a ramble today, so you might want to grab a coffee. Also, while I'm at it, if I say now, please click like, subscribe and share and all that sort of thing. It's apparently supposed to do it at the beginning of the video. And if you don't like it, you can always unlike it and unsubscribe. So that seems fair. But I'm planning a series of videos on how to conduct courtroom advocacy. So if people find themselves having to self-represent, they at least, have a basic understanding of the best way to do it. But that got me thinking, perhaps first I should explain how we actually teach the barristers, because I'm going to be using a lot of the same sort of techniques in terms of explaining to people and all the guidance we give. But how do we actually test that? First, let's just explain how people qualify as a barrister. You do a law degree, or you do any degree, and then you can do a conversion course that teaches you the core law subjects and converts any degree into what we call a qualifying law degree. And that allows you to then apply to go to bar school. Now, I'm old enough that there used to be just the one bar school back in the day, the old Inns of Court School of Law. But now the bar course is offered by about 8 or 9 different universities and organisations. They learn, all the basic law on your law degree. The practical stuff is what you do on, the bar course. They're all the procedural things. But how do you actually teach advocacy? Well, they do teach advocacy on these courses. However, there is additional training, both after they've qualified. When people are what we call pupils, pupillage is that 1-year apprenticeship you do after you've done your bar course. So, you actually get called to the bar before you're allowed to actually practice, because you get called to the bar, then you have to get pupillage. And you do 1 year of sort of on-the-job training under your pupil supervisor. For your first 6 months, you're not actually allowed to do any work yourself, apart from what we call noting briefs, where you can sit there and just keep a note of the trial. After your first 6, though, effectively you're on like a provisional driving licence. But you are allowed to appear in any court in the land. So, theoretically, you could end up in the Supreme Court as a pupil. But we teach both during pupillage and then post-qualification. And when I say we, who does this? Well, first of all, let me explain about things called, the Inns of Court and circuits and bar associations. The Inns of Court, there are 4 Inns of Court: Gray's Inn, Lincoln's Inn, Inner Temple and Middle Temple. Middle Temple's the best, yay. And they are, effectively the only organisations that can actually call you to the bar. And all barristers have to be a member of one of the Inns of Court. They started out in probably the 13th century as effectively, like any livery company or guild, they were responsible for training people in the same way the Silversmiths Guild would train people to be silversmiths. And, if you reached the required standard, you became a member of that guild. But we didn't, a lot of the guilds and livery companies still exist, but they're very ceremonial. And at the Inns, we're very keen that it's not just, let's all get together once a year for the Lord Mayor's Parade. We try to be practical. So the Inns provide this training. The training can also be provided by what we call the circuits. Before we had sort of established regular Crown Courts, judges would set out around the country. They would go on assize, they have assizes, and they would go on circuit. And we still have circuit judges to this day, although now we tend to have sort of, permanent Crown Courts and High Courts in various sort of parts of the country. But that's the circuits still exist. And we have organisations which we just call the circuit. So, for instance, I used to be a member of the South Eastern Circuit when I practised in London mainly. Now I'm a member of the Western Circuit, even though I mainly practice in London. But that's just because it's my local circuit, and they do social events as well. So it's nice to be able to sort of, be local for when they're having a nice meal or just meeting in the pub or something like that. But the circuits, and you don't have to be a member of a circuit. It's a sort of voluntary thing. But the circuits, they provide this training as well. There are also various bar associations, like there's the Criminal Bar Association, that criminal barristers join. There's the Family Law Bar Association that family lawyers join, and it's pretty much an association for every area of law. Again, those aren't compulsory to join, but a lot of people do. But how do we do the training? Well, we use something called the Hampel method, Hampel, named after a Professor Hampel, an Australian guy, who promoted this particular form of training. Although arguably it had been around before, the National Institute of Trial Advocates in America use a very, very similar system. There was actually a bit of debate as to exactly who invented it, and but that's perhaps a video for another time. But the methodology is, people get taught how to do case analysis and how to prepare a case and how to best present a case, and that's what I want to do for you. But how do we sort of test that and get people up to scratch? Well, the Hampel method it's what we call the vignette method, and it breaks things down into 6 categories. So this is how it would work. We cover both witness handling and what we call narrative advocacy. Witness handling is examining in chief, cross-examination, that sort of thing with witnesses. Narrative advocacy is when you are directly addressing a judge, say an application for an injunction or a bail application or a plea in mitigation. And we prepare exercises where effectively they're just based on real cases. So we give them all the papers that they would have in real life. And then we get them to do the advocacy. So they might have to examine a witness or cross-examine a witness or make a speech to a judge. But we then pick on one thing that stands out and would be room for obvious improvement. So we'll go through, they might be making lots of mistakes, they might actually be really, really good, but there's always something you can find. And the idea is to do something that they can immediately remedy. So we're not trying to make them perfect, we're just trying to make them slightly better than they were before, and we keep doing this until they get good. So we will give them what we call the headline, and it could be something obvious like don't ask leading questions, although we try to make them memorable. So I might use one I use a lot is it's not the witness you're trying to persuade, it's the judge or the jury, or if you're not interested in your witness, why should anybody else be? That's when people are just asking the questions without engaging them and making eye contact and things like that. So, there's a huge list of categories, but you pretty much have to do it on the fly. You have to spot it yourself and come up with the headline yourself. We then do what we call playback. In other words, we read back to them, we stand next to them and we read back to them what they did. And we point out, where we think they're going wrong. We then give the rationale for why we say that's wrong. This will lose the interest of the judge, you'll let the witness get out of control and therefore the evidence won't come out the way you want it to, you will bore a jury, people can't hear you, it can be anything like that. We then suggest a remedy. And it could be something like you need to structure this better, or you've got a nervous tic where you're always adding to the end of questions, that's right, isn't it? Just lose that. Speak up. A common one is slow down. We always, one I use a lot is you are allowed to breathe, because people, even we all do it, even experienced barristers, sometimes, time seems to move differently in a courtroom. So there is a tendency to sort of rush through things. But again, that's a bad idea because you need people to absorb this information. So we'll explain the remedy. Then, this is the hard bit, we have to demonstrate it. And it's always meant to be that we are supposed to be promoting excellence in advocacy. Now, because we've got no idea how they were going to prepare their case or how they were going to present it, we can't prep this in advance. We just have to go, okay, I can see what you were trying to do there. This is how I might have done it. And you will stand up and demonstrate it. And sometimes you make a complete mess of it yourself. You'll stand up and go, oh, actually, and this just shows how hard it is. Then you will have the replay. We will get the student to have another go, taking on board what we said. Sometimes we'll do that straight away. Sometimes we'll do delayed feedback, right? Okay, you've heard what we've said, go away and have a think about it and, maybe prep and, redo your notes or redo what, if you've written things out or rewrite your questions. But, in real life, sometimes you do have to do things on the fly. So we say, right, okay, we've told you now, don't just copy what I've said. Take on board what I've said and have a go. So that's the general principle. And the idea is we concentrate on one thing at a time. Sometimes we do it, if somebody is absolutely brilliant, we might say, well, that's great, but here's how you could improve. So we do the same thing. So we'll give a headline and say, you could be tighter, or cut out get rid of the wheat from the chaff, or trim the fat. That's a very common one where people are quite good. It's just like, no, but here's how you can just take it to the next level. But we still do the same thing. This is what you were doing. This is the reason that it could be better. This is how I might do it to be better. Now you have a go. So that is the methodology. And like I say, we do that both when people are in the pupillage stage, and also what we call the new practitioner course, which is within the first 3 years of them being out in the wild, actually being proper barristering. They have to do this course. Now, the Hampel method is used by so many jurisdictions. It's used obviously in the UK, in England and Wales and Scotland and Ireland. It's used in Australia, South Africa. It's used in like lots of places in sort of Africa generally. It's used in sort of India. It's generally regarded as quite a good methodology, although it's not without its critics. And we vary a little bit. Some organisations are very, very strict, doing like, do not vary from the sort of like 6 points, identify it's the headline, break it down very simple. Other times it's a bit more free form, where you might use that as a basis. Also, if you get people who are very, very good, you might just give them some general points. But we're trying to teach people how to present arguments and make points very clearly. So we need to be able to do that ourselves, using this methodology. So even if we get in sort of just general feedback, we will always try to do it in basis of, here's the point we've identified, here's the rationale for changing that, here's some thoughts on how you might like to change that, why don't you have another go? So yeah, so that's the Hampel method. Like I say, I've taught this in, various countries around the world, and it's always very interesting, even though we're using the same method, to see how people adapt in different jurisdictions to sort of the local courtroom culture. I mean, I was over in Hong Kong recently, and because there is a culture of deference and never being too assertive with people or too challenging. That is very interesting in terms of cross-examination, for instance, because the purpose of cross-examination is to put words in somebody else's mouth. But that's considered to be sort of quite rude. So we learned very quickly that might have happened meant yes, definitely did happen, and things like that. So you do have to adapt. And part of the fun of doing all the stuff abroad is we learn from each other. So there you go. So that's how people, that's how barristers are taught. But what I'm going to do is also we teach like case analysis and how to prepare a case and how to sort of, present it in the best possible way to the decision maker, whether that's the judge or the jury. And that's what I want to do for you. But I just thought, you just might like to see, how we do it in the trade. So there you go. And like I said at the beginning, if you like that, please consider liking, subscribing and sharing. And if you didn't like that, but you'd already clicked like, now's your time to unlike it.